Yes, Mrs. Karpasitis.
In summary, yesterday, my lords and my lady, I submitted first that my learned leader should have been permitted to cross-examine Mrs. Vine and Mr. Alan Smith about the credibility issue based upon Mr. Cook's evidence, and that he ought to have been permitted to do that without the statement being formally admitted into evidence, and the alternative that Mr. Cook's evidence, or at least part of it, should have been admitted simply for that purpose. In the alternative, I submitted, if the court did not accept that that was the proper course, that on the issue as to whether the appellant and the court were bound by Mr. Cook's evidence, once it had been admitted in its entirety, I sought to demonstrate that it was open to the lower court.
Sorry, can you keep your voice up? You're competing with some loud noise outside.
My apologies, my lord, I will. That on the issue as to whether the appellant and the court were bound by Mr. Cook's evidence, once it had been admitted in its entirety, I sought to demonstrate that it was open to the lower court as a matter of law to find that Mr. Cook was mistaken, and that that is the finding that the learned judge should have made. I took, my lords and my lady, to the case of Burnett versus Lynch to demonstrate that the court can reject and accept different parts of a witness's evidence. There is an additional paragraph that I wish to take my lords and my lady to, which is tab 16 of the bundle of authorities at page 275, paragraph 20. To make what I hope is an uncontroversial point, that judges are very frequently faced with having to make an assessment about whether a witness is correct or accurate without going so far as to making the finding that they are untruthful. In the alternative to my submission about the finding that should have been made that Mr. Cook was mistaken, I sought to demonstrate that as a matter of law it was open to the appellant to challenge Mr. Cook's evidence that he conducted a walked inspection as being untrue, and even if the appellant was not so permitted, that it was open to the court to make that finding. My lords and my lady have the submissions of my learned leader as to why the GPS data demonstrates that Mr. Cook did not conduct a walked inspection, and we concluded that yesterday's hearing with me taking the court to Lord Justice Males's reasons for giving permission to appeal, and his reference to the GPS data in those reasons. So that's where we left matters yesterday.
Well, speaking for myself, I'm actually rather mystified as to why the GPS data wasn't admissible of its own, on its own anyway. Could have been put into evidence irrespective of whether it was put to somebody. Doesn't it speak for itself?
It does, my lady, and also I was going to take my lords and my lady to the GPS data again in terms of weight, because what appears to have happened is that it was admitted, but that the judge attached very little weight to it. That was my understanding of what he said about the GPS data, and I would like to take.
Oh well, that would be. It would be helpful to see that, I think.
Yes, well, perhaps we should look at it again. I don't recall what led him to the effect in it.
Judgment is in the call bundle at tab 9. If I could take my lords and my lady first of all to paragraph 71, which is at page 96. Where the judge says, I took account of Mr. Cook's statement and gave various parts of it differing weight, as will be apparent from my conclusions. I reject the suggestion from the claimant that the location/timing data concerning the car indicates that Mr Cook did not carry out the inspection at all. He then explains his analysis of the GPS data. He then says, about halfway down that paragraph, I accept that the location/timing data cannot be relied upon as accurate, and I therefore place minimal weight on location/timing evidence. So the judge appears to have assessed it not on an issue of admissibility, but on an issue of weight.
Accuracy, but I accept that the location timing data cannot be relied on as accurate. Why?
Well, that's exactly our point, that there is no proper analysis, we say, in the judgment as to why he rejected that evidence.
I mean, the defendant said it was not accurate, or there was no admission as to its accuracy. But as I have read that, it was accuracy to the second or the nanosecond of the timings on it. But actually, if you look at it, stand back and look at the overall picture that it presents, you can't say that's inaccurate. No, it doesn't exactly tell you where he stopped along the A10, whether he got out of the car or not. But what it does tell you is that 3 minutes isn't long enough to carry out this inspection.
Ms. Maloney, what the lower court appears to have done is simply accept the defendant's bold assertion at trial that evidence is inaccurate, whatever that means.
Yes.
And then the only references to it, as to the judge's assessment of it in the lower court, are at paragraph 71, and then also at paragraph 136 at page 111.
But also, it seems to be, and it may well be, the judge seems to be working on the assumption that your case, your side's case, was that there was no inspection on that day. I thought the case was that there was no walked inspection. It wasn't suggested he wasn't where he said he was. It wasn't suggested that he wasn't in the car and that he wasn't driving around, but that the inspection that took place was a drive-by inspection rather than a walked one.
That's correct, my lady. That's also my understanding of what happened at first instance. And
Yes.
plainly, a driving inspection would not have been sufficient to establish a Section 58 offence.
Yes. And so the judge is labouring under the misapprehension that your case is that Mr Cook is telling a tissue of lies when he says he was in that particular area of the Cambridge Road at all.
Yes, ma'am. And then we have paragraph 136, which is the other paragraph in which the lower court addresses the GPS evidence. And the judge says, 4 lines down, the defendant's position is that the GPS evidence is not agreed to be accurate, as made clear in the defendant's email disclosing it on 18th of May 2022, nor is there any evidence of its accuracy or its proper interpretation. And then further down in that same paragraph, the judge says, I accept the defendant's submission on the GPS evidence, and I'm unable to place any weight on that evidence.
Sorry, I was behind you. Sarah's
Sorry, my lord, it's page 111 at paragraph 136 of the judgment.
Oh, yes. Yes, thank you.
I'll give my lord a moment to read that paragraph.
Well, that seems to be saying that because of Property Alliance Group and Royal Bank of Scotland, if a statement is put in, as Mr Porter put it in, it becomes incapable of being challenged or controverted by any evidence such as GPS evidence, therefore reject the GPS evidence as plainly inaccurate because Mr Cook's witness statement was equivalent to the 10 Commandments.
That seems to be the case, but also what the judge at first instance has done is to still go on and assess weight in relation to Mr Cook's evidence. And so implicitly, I suppose, an acceptance that the court is permitted to look at weight, despite the finding that's also been made in that paragraph that because of the Property Alliance case, that the appellant themselves couldn't have sought to challenge that part of Mr Cook's evidence. In the Filiatra legacy, which I took my lords and my lady to yesterday, the evidence of Captain Bellucci was also assessed in relation to weight, and that is tab 3 of the bundle of authorities at page 51. And this is the right-hand side of the column under G conclusions, the second paragraph beginning, how then is Captain Bellucci's evidence? It says, how then is Captain Bellucci's evidence to be brought into the scale? We have rejected the proposition that it must be assumed to be true. Conversely, we can see no logic in leaving it out altogether. The only course, so far as we can see, is to treat his two statements as evidence in the case in the same way as all the other Civil Evidence Act statements, and giving them such weight as the circumstances require. And so, looking at what weight the judge gave to Mr Cook's evidence, going back to the judgment, I've already taken my lords and my lady to paragraph 71 of the judgment, and in that, at page 96 of the core bundle, the court is saying that he's taken account of Mr Cook's statements and given various weights to differing parts of it. The judge says, as will be apparent from my conclusions. And then at paragraph 72, which I invite my lords and my lady to read, the judge looks at the reason for Mr Cook not giving evidence. I can give you a moment to read that paragraph. Appears to be saying there that he's placing less weight on Mr Cook's statement than he might have done, and but then goes on to say there might be other reasons why he didn't wish to attend, other than that he didn't conduct a walked inspection. Then we go to paragraph 134, paragraph 134 of the judgment at page 110. I can invite my lords and my lady to read that paragraph, please. Where the judge appears to take an inconsistent approach to paragraph 72, in which he concludes that the reason that Mr Cook gave for declining to attend court was unsatisfactory. When one looks at the findings that the judge actually made in relation to Mr Cook's evidence, in my submission it shows that the only part of Mr Cook's evidence which the judge attached less weight to was the categorisation of the defect. And if I could take my lords and my lady to paragraph 123 of the judgment, I believe this is the distinction that leading counsel for the respondent was referring to yesterday during my learned leaders submissions. Paragraph 123 at page 108. Where the judge said, I find that the defect in this grass verge case was dangerous and called for repair, albeit it was not urgent, for the following reasons. Now, not urgent must mean implicitly that that's not category 1. And then he says at Roman 4 over the page, as one of the reasons for making that finding, both Mr Cook, the highway inspector, and Mr Martin, contract manager for grass cutting, were both clear that if there was a substantial hole on 22nd of April 2020, it would be category 1 and had to be repaired quickly. So there's an inconsistency there between what the judge saying he was finding and the reasons that he gave for that finding.
Well, I think trying to sort of factor those two findings together. He seems to be accepting it for the Cook and Martin categorisation,
Yes.
and yet he says it's not urgent.
Yes, that's the part
Which is
that
weird.
puzzling.
Yes.
And
One would think in a common sense world that if there's a hole in an infrequently used spot, but which is dangerous, would be dangerous to pedestrians or cyclists, that putting a cone or some other warning item by it would be quite good as a start, even if you don't have to carry out repairs within 24 hours.
yes,
I don't know whether any witness was asked about this.
well, Mr. Cook's evidence deals with what he said he would have done.
He would have put a plate
He
on
would
it.
have put a plate
Yeah.
in. And that's tab 14 of bundle A. And it's paragraphs 9 and 10 of Mr. Cook's evidence at pages A115 and A116 of the bundle. So he says he would have put a metal footway plate over the hole and then made arrangements to have that made safe. And he says at paragraph 10 that he would have categorised this as a category 1 24-hour sunken grass verge. Please make safe with appropriate footpath. The only explanation that I could come up with for the rejection of the evidence about it being urgent in my submission must be that the judge at first instance accepted the new evidence given orally by Mr. Vine and Mr. Alan Smith that Mr. Cook would not have given it a category 1 status but would have given it a category 2 status. And if I may take my lords and my lady to
I don't see how you square that though, Ms. Carceres, with the finding at Roman 4.
It is puzzling, my lady, as to how those two fit together. In my submission, this is an example of the point made by Lord Justice Males when giving permission that this judgment shows evidence of having been prepared at different times, and that may explain the inconsistencies that we're able to identify now. But if
on the face of the judgment, if we're having to, because he doesn't actually say category 1 or category 2, but says instead dangerous but not urgent, so we're having to translate that to being potentially category 2. The only thing he says about it not being urgent is little Roman 5, paragraph 1, 2, 3 that you were just showing us.
yes, not necessarily
Which
have to be urgent.
doesn't seem to be linked to what those two witnesses said about what Mr. Cook would have categorised it as, but doesn't seem to be, I mean, that subparagraph at any rate is not linked back to any evidence or any other finding. But anyway, that on the face of paragraph 1, 2, 3 anyway, that appears to be the explanation.
Yes, if I could take my lord, this may help to the defect management approach manual, which deals with category 1 and category 2. This is bundle A at tab 2, page A14. Halfway down the page is category 1, the definition of category 1 defects. And that has in brackets 2 hours, 24 hours, 5 working days and 20 working days are defects that require prompt attention because they represent an immediate or imminent risk of one of the following. And then in relation, underneath the bullet points, it then says category 2 defects are all defects that are not categorised as category 1 defects. So the judge doesn't appear to have been saying it was category 2, but he does say it was non-urgent, which doesn't quite fit neatly into category 1 either, based on that definition.
Well, it's very puzzling because he finds it's dangerous, and it can only be dangerous if it presents an immediate or imminent risk of injury.
Yes.
That's the reason it's dangerous. Because somebody might fall down it.
It does rather beg the question as to why the judge decided that it was not urgent. The only explanation that I could think of was his acceptance of Mr Vine and Mr Alan Smith's evidence. And this is at paragraph 60 and 61 of the judgment in core bundle at page 94. My lords and my lady, to read paragraph 60 and 61.
Sorry, page number again.
Page 94, my lord. The court will note that the judge has made an error in paragraph 60 where he says he maintained the view that Mr Cook, this is in relation to Mr Alan Smith, would have flagged the defect as a category 2 medium, which would have been misleading had he known what Mr Cook's statement said. But that was not demonstrated to the court at that point. And I took my lords and my lady to the transcript yesterday of Mr Alan Smith's evidence, where it is very clear that he was aware of Mr Cook's statement when he gave that evidence.
He seems to there be, the judge that is, seems to be thinking that that was not demonstrated to the court at that point. When Mr Cook's statement was disclosed, then Mr Alan Smith was entitled to continue. So he seems to be, well, it looks as if he forgot that Mr Alan Smith said he had seen the statement.
Yes. So despite saying it was not urgent, the judge did go on to find at paragraph 126 of the judgment at page 109 that in all the circumstances he concluded that the defect was dangerous as of 22nd of April 2020, which was the date of the accident. He then says at paragraph 133 of the judgment at page 110, it is clearly of assistance to the defendant that it employed an experienced inspector, Mr Jeff Cook. Mr Cook says in his witness statement that he would have spotted a hole of that size had it been there. I have found that the hole was probably not present on 13th of February 2020. That must be based in my submission on the judge's finding that it was a walked inspection rather than a driven inspection, which led to him making that finding.
Well, I think Mr Weitzman is going to say, what about the rats?
Yes, there was a debate about whether the rats had made a difference to that. But in my submission, given the judge's findings on Mr Cook's evidence, what he placed more weight on was the fact that it was a walked inspection, and on that basis, if the hole had been there at the time of the inspection, that Mr Cook would have seen it.
Was he not also entitled to rely on the fact that there were the grass cutting operatives who said that they didn't see it in about 3 weeks before the accident?
Lena reminds me that the judge was entitled to, but that he didn't. I would need to find the reference to.
Oh, I thought he did. I was just looking at a. The trouble is that because of the structure of the judgment, I sometimes struggle to find out when he's simply reciting what one side's case was, and what the evidence was, and which bits are his findings. But
Yes.
that there is a passage, is there not, in the judgment, if one looks at 97, that he deals with the grass cutting people, and he says, first of all, that 73 deals with Cook's document that talks about no defects in the grass verge. And then he talks about Mr Darcy and Mr Harris and what they say would have happened if they'd seen it at the grass cutting at the location of the accident in April, which was about 2 weeks before the accident, something like that. And they say what they would have done. And then I thought a bit later on he said that he accepted their evidence. 76, he accepts Mr Harris's evidence, and he says he had no reason to disbelieve Mr Darcy. So that is evidence from two separate witnesses who, on the basis of which the judge could have found that there was no hole as late as the 7th of April, isn't there?
My understanding of this section of the judgment, my lady, is that it's in the context of talking about the size of the hole on the 22nd of April and on the 13th of February.
Yes.
And I think this part of the judgment, or I submit this part of the judgment, also needs to be seen in light of the judge's...
Sorry, 110 on page 106.
One of the leader mentions paragraph 110 on page 106.
Ah, yes, that's the answer. Yes. Yes, thank you.
In my submission, the weight, the finding that the hole that was present in April was not present on inspection must have been based mostly upon Mr Cook's evidence that he conducted a walked inspection. When one looks at the weight that the judge gave to Mr Cook's evidence, despite the judge's comments that he was going to give differing weight to different parts of Mr Cook's evidence, in my submission, his intention did not follow through appropriately or correctly into his findings in the judgment. And I say that's an example of Lord Justice Males's observation when giving permission to appeal, that the judgment shows signs of having been prepared at different times.
Yes, you have made that point a number of times now.
Yes.
You have got it.
But in summary, there appears to be less weight placed on the evidence that it was a Category 1 defect, more weight on there being a walked inspection because there was an incorrect approach in my submission to the GPS data. And that's demonstrated by the judgment. So overall in my submission, the judge has made errors when assessing the weight to be given to Mr Cook's evidence. And in all the circumstances, we submit that the judge ought to have drawn an adverse inference from Mr Cook's absence at trial, namely that he had not undertaken a walked inspection, or at the very least, he ought to have placed little, if any, weight on Mr Cook's evidence in his statement that he conducted a walked inspection and that the hole was probably not present on the 13th of February. One of the strange aspects of this case is that it is well established that the general rule is that oral evidence given under cross-examination is the gold standard. And in relation to that, we rely upon the case of Carmarthenshire at tab 19 of the bundle of authorities at page 341 at paragraphs 7 and 8. And I note the respondent's challenge the reliance on this case on the basis that it is a family case, but in my submission it is well established that cross-examination is the gold standard. The issue that appears to have come about in this case is that Mr Cook's evidence that was not tested by cross-examination has been given a different status simply by the appellant putting it in as evidence, even though both parties challenged different parts of it, and that evidence was given greater weight than, say, evidence tested under cross-examination, which instinctively does feel wrong, given that we know that cross-examination, that evidence under cross-examination is the gold standard.
Yeah. If we hadn't had this episode with Mr Porter ending up putting the statement in himself, if matters had just stood the service of the Civil Evidence Act notice saying he wouldn't be coming because he was retired. Mr. Weitzman couldn't have relied on his statement at all, could he? And it is some time since I last looked this up, but Civil Evidence Act notices which say that the witness is dead, obviously, can be the statement can be put in. Beyond the seas, in the old wording, the statement can be put in. It goes to wait. But if it's just he can't be bothered to come, you can't use the statement at all, can you?
Well, that's in fact was their intention by the time of trial, was not to rely on the statement, even in its written form. But the Civil Evidence Act notice was not served at the same time as the witness evidence, so it was served late in any event. But there was never a debate about that at first instance, because the defendant's approach at first instance ended up being, we don't actually want to rely on it.
No, I mean, they quite rightly gave you notice that he wasn't going to come. Would have been would have been very undesirable simply to turn up on the day and say, oh goodness me, he's not here.
Yes.
So you did have warning, but
we did, not very long before trial, but yes, we did. Although I think the hope was that he would come for cross-examination, but obviously that didn't happen. I was going to move on from submissions in relation to weight in the judgment and take, my lords and my lady, if I may, to whether the court has an inherent discretion to impose a condition that a party, in this case the appellant, should not be treated as being bound by the evidence of Mr Cook, or having accepted the entirety of it by reason of putting the statement into evidence. And the case that I rely on in relation to that is called Towery versus Bennett, which is at tab 15 of the Bundle of Authorities. At page 265, paragraphs 23 to 25. This is a judgment of the High Court, and this was in relation to oral evidence. I appreciate here we're talking about written evidence, but in my submission it does demonstrate that the court does have an inherent discretion to impose a condition that the appellant should not be treated as being bound. And the conclusion, the parts of the judgment that deal with this are paragraphs 23 to 25, but in paragraph 25 the judge found that the party that was affected in that particular case should not be treated as being bound by the evidence, and the judge agreed in that case that in the circumstances that evidence ought to be weighed in the balance along with all of the other evidence in the case. And in my submission it appears that at first instance, although my lords and my lady recognised yesterday that there were no real formal rulings in this case during the course of the evidence, but there was a point which, in my submission, looks like a ruling on what the appellant would be permitted to do in terms of weight, and that is in the transcript, bundle B, at page 160, tab 5. Page 140, my apologies, I was looking at the internal page reference. B140. And there are some submissions by my learned leader who says at line 18, we're significantly hampered in the prosecution of our case because of his last minute absence. And the judge says, well, if you can't cross-examine, then that's obviously a factor going to weight. The learned leader says yes, and the judge says if the statement is in. Arguably, the judge in that case had exercised the Towery discretion, if I can call it that, and ruled that the appellant wouldn't be bound by that evidence in this case. And
No, he didn't give a ruling.
but there wasn't
so
a formal
it's rather
ruling.
difficult.
I recognise that.
To
That's
read
the
that in.
closest we get to a ruling. And it would be justifiable in this case, in my submission, to allow a party to cross-examine as to date, because unlike the respondent, the appellant had not had the opportunity to interview Mr Cook and test his evidence before deciding whether to put his statement into evidence. And my learned leader took instructions about whether to reduce the entirety of Mr Cook's written statement on the basis of what was at the very least an indication by the judge on the issue, and a decision was made to put the statement in on that basis. And at that time, there was no contradiction in my submission that that was the appropriate way to do it. The judge's conclusion that he couldn't reject part of Mr Cook's evidence appears to be inconsistent with that indication, that it would be a question of weight which would be considered later in the case.
Right, how are we doing on time, Miss Katz?
I have,
You said last night that you'd
yes, I will take it very shortly.
be up to half an hour, and we're
Yes.
3/4 of an hour in and finished.
I'll take it very shortly if I may, my
Yes,
lord.
please.
A short point on burden and standard of proof. We say that in relation to the issue as to whether Mr Cook had conducted a water inspection, the burden was on the respondent to prove that it was a water inspection, and the standard of proof should have been the balance of probabilities. And this was a very different situation to the Filiatra legacy, where the assertion was that a serious crime had been committed. What the judge said was that he required cogent evidence that Mr Cook's evidence was untrue, and that in my submission was an incorrect approach as to the burden and standard of proof. This was a routine personal injury claim. The allegation itself was not inherently unlikely, nor was it sufficiently serious, nor do sufficiently serious consequences flow from it to merit the approach of requiring more cogent evidence. And in reliance on that, I rely on the case of Burnett versus Lynch at tab 16. That is my lords and my lady to it now, but it's paragraphs 24 and 25 of that judgment at pages 276 and 277. This wasn't like an allegation of fraud where it's the balance of probabilities, but you need more cogent evidence to demonstrate it. So in my submission, this should have been a straightforward burden on the respondent, standard of proof, balance of probabilities. My final submission was the second point that I outlined yesterday at the beginning of my submissions, was that when determining the facts, the judge at first instance should have appreciated that his acceptance of Mr Cook's evidence in relation to the dangerousness of the defect should not preclude or inhibit him from finding that Mr Cook's statement was mistaken or not truthful in relation to the wart inspection. There was a distinction between the types of evidence that Mr Cook gave. So in relation to the categorisation of the defect, this is what he would have done if he had seen the hole, and that's not a question of memory, that's a question of him exercising his judgment. And I've taken my lords and my lady to the defect management approach, and at a number of points in that document, it makes clear that it is a matter of the highways inspector's judgment as to make an assessment of the defect. And so that is a question of what he would have done if he had seen that defect. His evidence about whether he conducted a wart inspection is a question of fact or recollection, which is in my submission.
Attention please, attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers.
I'm afraid we have to do this. It's happening more and more nowadays. nowadays. Sometimes it's a drill, sometimes it's not.
This isn't a drill,
This is a real one. Well,
Attention please. Attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lift. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. lifts. Follow the instructions of
Attention please. Attention please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing. Attention please. Attention please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing.
Should have done.
You ready to continue? Great.
Court rise in favour. My Lords, my Lady, before completing my submission, I just wanted to give you two references in the authorities, if I may. The first is the case of Philamy at tab 7, page 120 of the bundle of authorities at G to H, to demonstrate that the appellant can contradict part of a witness's testimony, and that doesn't preclude them from relying on the rest of the testimony. And the case of a county council versus KD and L, which is at tab 12 of the bundle of authorities, page 208, paragraph 28, to show that even if the court were to conclude that a person is lying about parts of their evidence, it doesn't mean that they're necessarily mean that they're lying or not telling the truth about another part of their evidence.
Yes.
So,
Just give us the reference in McPhillamy again.
McPhillamy is page 120 of the authorities bundle at paragraphs G to H. And in the case of a county council versus KD and L, it's page 208 and 209 of the bundle, paragraph 28.
Yes.
Unless I can assist further, those are my submissions.
Thank you very much. Yes, Mr. Wise.
My lords, my lady, I had hoped to be finished by lunch because I thought I'd be getting a clear start, and
Yes.
the fates have conspired against me.
Yes.
I'll try and deal with matters as concise as possible. I think I should be free to 4 hours. I accept that. But I have to deal both with the appeal and cross appeal.
You do, yes.
Can I deal with, as an initial issue, it was said that there had been a change in our case, and that's said both in the transcript and the bit we're going to look at in relation to the argument about Mr. Cook, and also in relation to, it was said yesterday. There was no change in the respondent's case. The respondents both advanced the case under section 41 and the statutory defence under section 58. They are alternatives. It's entirely normal for that to be done. If you look in the core bundle, please, at the defence, which is behind tab 12, page 127, you can see that the argument which I will seek to make later today about the verge in section 41 is clearly set out there.
Yes.
It was in the respondent's skeleton at trial, and I'm just going to give you the reference rather than take you to it, if I may. Paragraph 7.6 and 7.7, B25. And in fact, when my learned friend opened the case, he identified that element of the respondent's case. So it is not the position that there was a surprise or sudden change in the case advanced by the local authority. It is right that the arguments in relation to the verge were principally advanced by our expert, Mr. Hopwood, but of course that is entirely normal, because when one is considering what a highway authority should or should not do, it's to be judged by reasonable standards across authorities, and that is a matter of expert evidence. So it was entirely appropriate for the expert to deal with that, who obviously came in the normal order of a trial after the lay witnesses. Can I now deal with category 1 and category 2? Because it's obviously led to some confusion. I agree with my learned friend, that the judge and my Lady Justice, that you cannot have a dangerous defect which is non-urgent, because that would make it a category 2. So there was some confusion, I accept, in the judgment about that, and that's one of the reasons we say his finding in section 41 is unsound. If I could take you to bundle A, please, to the part that my learned friend took you to recently. You have behind tab 2 A9. The defendant's defect management approach inspection manual. This is what's referred to in the transcript by the witnesses as the DMA. It is the Hertfordshire Highway Authority's manual for inspectors. It reflects the national guidance which is set out in the well-managed Highways Infrastructure Code of Practice. That's a national document which local authorities look to for guidance, although it's not prescriptive. Mr. Alan Smith gave evidence about that at paragraph 4, reference A79, and that's also dealt with in the judgment at paragraph 49. The DMA was before the judge, and one looks at what my learned friend took you to, A14, which identifies category 1 and category 2 defects under the definition section 2.2.2. And then if we could turn the page to A15.
Just before you leave that,
My apologies,
I have asked your opponents, but what's the significance of 2 hours, 24 hours, 5 days, 20 days?
If I can go through the document, it will become clear.
It will become right.
I'm most grateful, my lord. 2.2.3 on page A15, inspection objectives in relation to category 2 defects to the extent of different parts of the network of different defect classes required, allowing for full and proper compliance with the requirements of HST category 2 service and a defect management approach, assess and decide strategy. And this really comes to the issue that my Lady Justice was asking about. Where you have a category 2, it's not urgent, and so it's part of a rolling programme of works, which is the assess and decide strategy. And we'll see that if we go to page A21, hazard mitigation, 2.4.1. And if you look there, in relation to category 2 defects, hazard mitigation will not be required, as by definition, a category 2 defect is not immediately hazardous. And then dropping down permanent remedy, for category 1s, permanent remedy time will be set in accordance with the defect class policy, and that will answer my Lord's question when I come to it. For category 2 defects, permanent remedy will be in accordance with the assess and decide strategy. If I can then take you to A25, which is the guidance for ruts on the verge, you can see you have the characteristic of the defect itself, greater or lesser than 100 millimetres, and that gives you a score of 2 or 4. And then potential defect probability characteristics, low. And so whether it's stones on the verge or a rut in the verge, you select the number 2, and you multiply 2 by either 4 or 2 to get either 4 or 8. And if one then turns to page A26, you can see you've got a category 2 medium, which gives you 5 to 8 points, assess and decide strategy, or a category 2 low, 1 to 4 points, assess and decide strategy. If we go to page A27 by comparison, you have for a footpath cycle track trip hazard, and you can see there you have a defect depth of 20 millimetres, and you have the likelihood of someone coming upon it depending on the footway. So where it says in the second box down, category 4, 5, category 3, 3, 4 or 5, 1 or 2, that's a reference to the frequency with which the footway is used, which you find at A17. And if I turn the page to A28, please, my lords, you can see there the different time scales depending on the level of risk. So very simply, the level of risk is identified by looking at the nature of the defect and the probability of someone coming across it. The Category 1, the higher the risk, the more urgent the timescale for the repair. Category 2, by definition, is not hazardous, and so it's part of the rolling system of works.
But
My lady.
what this actually suggests to me is that Mr. Alan Smith had got the wrong end of the stick when he was suggesting that a hole in the verge could only ever be a category 2 defect, which was his answer to the point that was put to him eventually at cross-examination about Mr. Cook. Because a rut is a rut, but it's not a large hole.
My lady, I accept a rut is not a large hole, but the evidence from Mr. Hopwood was that that's a technical description and it covers large holes.
Well, I'm sorry, but the man in the street would think that a large hole that a pedestrian could fall into is dangerous. And the idea that you've got some kind of measurable statistics that say that it's never dangerous is nonsense.
My lady, I'll come to Section 41 and the duties of the highway authorities, but they have to, by definition, use resources appropriately. And one element is identifying where the risk occurs. And if it is on part of the highway which is not used by ordinary traffic, then it has a much lower risk. If that hole had been in a carriageway or on a footway, it would have been an urgent category 1. But it wasn't. It was in a verge where they did not expect people to go. And because they don't expect people to use the verge, that is why it's category 2.
So that's a question of fact, isn't it? Whether you would reasonably expect people to go into that particular part of the highway. And if you're dealing with a narrow footpath, which is in fact and practice designated as a cycleway and is shared by both pedestrians and cyclists, there is every chance that somebody is going to go onto the verge in order to get round somebody who's using the footpath.
My lady, I would say it's a matter of law, and it goes to the content of the duty under Section 41, which I will address you on in due course. That is precisely the judge's reasoning that it was foreseeable that someone would go onto the verge, and because it was foreseeable, there was an obligation to repair. But in my submission, that extends the duty from that which it actually is. It in effect says...
You say as a matter of law, there's no Section 41 liability unless applying the defendant's manual, it would have been category 1. That's a proposition of law.
No, my lord. I say that as a proposition of law, there is no liability in relation to the verge. I say the defendant's DMA reflects the legal position.
But that's because you're using the word ordinary traffic.
Indeed.
Phrase used in Burnside and Emerton.
Yes.
If the position is that it's entirely foreseeable that pedestrians would use the verge, and the hole is dangerous to pedestrians, then the extraordinary traffic or extraordinary use exception doesn't apply, does it?
My lord, in my submission, yes it does. Because what one is looking at with a highway authority is the old duties of the parish council, which was to keep the highway in repair to allow people to pass along it.
Yes.
If you expand that to areas adjacent to the highway itself, you are in effect extending that to a more common law duty based on an assumption of responsibility to keep people safe. It is as if they had entered into a relationship like a doctor or an employer, giving rise to a duty to guard against all dangers, whereas the content of the duty in my submission is much more limited. It is to keep that part of the highway free for all, in good repair, which is being used. It would be the pavement, or the carriageway, or the footpath, or the cycle path. If not, all land adjacent to highways which form part of it will have to be repaired by highway authorities to allow any amount of traffic to use them.
If that's right, then your defect class description would be meaningless in relation to the verges, because if there's no duty in relation to the verges, then why is there class 2 defect at all?
Because if a verge is deteriorating, it may create a danger on the highway. So if you have a verge collapsing, it may result in a danger to the footway, a danger to the A10. And the fact that we seek to repair does not of itself give rise to a duty of care. That's plain for Mills versus Barnsley. It's not that we repair that gives rise to the duty of care. It's that it is within the content of the specific statutory duty. Remember, Section 41 is quite a high absolute duty. All the claimant has to do is prove a defect.
Well, it's subject to the Section 58 defence.
Absolutely, subject to the Section 58 defence. But if you are extending Section 41, an absolute duty to keep and repair to verges, you can imagine that it will greatly extend the obligations to highway authorities. You can imagine a country lane with verges, which will form part of the highway, rabbit holes, undulations, tree roots. It's always foreseeable that someone may leave the metalled path, but that does not mean that the duty is extended to those other areas.
Well, right.
Would you like me to address you on the law on this part now as we're here?
Well, I think that's quite convenient, because if you're right, then that's the answer to the whole claim. As a matter of law, there can never be liability for a hole in the verge, a summary judgment with costs, no need for a trial. That's a proposition, isn't it?
Yes, my lord.
Right, well, let's see whether it's right.
Can I lay out some principles then in support of that position?
Yes.
As we're going to go through Gorringe in a little detail, which is the authority we principally rely on, I will at the same time deal with the issue of the common law duty of care, because the two are interlinked. So I've got 8 propositions, if I may.
Cool. Right.
One.
Are they in your skeleton argument, or do we have to take them down?
I think they are in my skeleton argument, but I try to distill, so it may be helpful. One, in a highway authority, like any normal person, owes duties when they create a danger by a positive act, but they're not liable for failing to take steps to abate a danger, using Lord Reed's judgment in the case of Paul for failing to confer a benefit. There's no distinction in law between a positive step and a trap. They're not two separate things, they are the same thing. So if you take a positive step which creates an unreasonable risk or a danger, then that is an effective trap. The failure to erect a sign is an omission.
Sorry, I'm very pedestrian.
I apologise, Mike.
You've got 8 propositions, and I'm looking forward to them. I think that's the first, is that right? So in my note, do I come to a second?
The second was the distinction between a positive step and a trap, my apologies.
Oh, okay, right, yes.
The third is a failure to erect a sign is an omission. And so there is no common law duty because the sign conveys information and therefore a benefit.
Yeah.
4, contrary and cutting across the common law position as I've just outlined it, is Section 41 of the Highways Act 1980, which is a consolidating act and puts in statutory form the previous duties of the inhabitants of a parish, which was an obligation to keep the roads in repair. It also creates a private law duty, breach of which can result in action for damages. 5.
Sorry, Mr. Watson. If you want us to write this down,
I'm so sorry,
you'll have to go a lot slower.
I do apologise.
Or you can say it's in the skeleton argument, but I don't do shorthand.
I do apologise, my lord.
So section 41 cuts across common law liability, puts into statutory former liability of parish authorities. Right, keep going.
5. The statutory duty under section 41 is limited to the old obligations of the parish to keep the highway in repair.
Yep.
6. The purpose of that obligation, Burnside versus Emerson, my lord, as you've identified, is for the ordinary passage of traffic, using the highway in an ordinary manner. 7. The obligation to repair cannot be expanded to an obligation to make the highway safe. The highway authority is not an occupier. And we say from that it follows that it's not obliged to maintain those parts of the highway which ordinary traffic is not expected to pass along. Which leads me to 8. There is no obligation to repair the verge. It's not within the content of the duty under section 41. Dealing with my lady's point, while we may inspect the verge, that does not create a duty to repair it. That would be contrary to the content of the duty.
Contrary to?
The content of the duty.
So you've got an obligation to inspect it, no obligation to repair it, even if it makes the highway unsafe.
Well, my lady, it's my submission that it does not make the highway unsafe.
No, but you told me in answer to a question a little while ago that the reason that one might want to repair a rut in a verge is that it might make the highway unsafe. You're now telling me that there's no duty even to do that.
No, my lady, I'm sorry I wasn't clear enough. If a hole in a verge will extend into the footpath so that it makes, for example, here the footpath unsafe, then part of the assess and decide strategy would be to repair it before it got to that position. But it's only if it damages those parts of the highway which give rise to ordinary traffic that you're into a breach of the section 41 duty. So they inspect it in part to carry out works to avoid in the future that defect affecting those parts of the road used by ordinary traffic.
And you say it's not even a question of fact whether the verge is at the side of a very wide footpath or a narrow one. Just as a matter of law, there can be no obligation to repair a verge, and that's that.
Yes,
Okay,
so
it's as simple as that.
may I illustrate that? If you
Well,
have, I do agree with that proposition.
Has that ever been held before in reported cases, or is this going to be the one?
No, I will take you to cases which, in my submission, deal with precisely that point.
Right.
They are 2 first instance decisions because it hasn't come before the Court of Appeal.
Ah.
Save in a case called Thompson, where the issue was a ditch, and it was said that the Highway Authority had no obligation in relation to the verge to flatten it out from its natural undulations.
All right, well, let's look at the case.
The starting point, my lord, is Gorringe. Which we find in our authorities bundle. Behind divider 11, please.
Yes.
And I'm not going to cite, there are a number of entries we need to go to, but I'm not going to read it all out. Paragraph 11, page 175, identifies Burnside and Emerson test. Paragraph 13 identifies the old duty of the parish. And Lord Hoffman makes the point that saying they're not liable outside the duties of the parish was sometimes said to be an exemption, but in fact it's not an exemption, it's simply a failure to act and confer a benefit.
Sorry, I just need to read through this paragraph.
My apologies, my lord.
Yes.
And my lord, I say that's the intersection of the section 41 and the common law, because absent section 41 duty, there is no obligation to confer a benefit, to take positive acts. And the Highway Authority hasn't assumed a responsibility other than in relation, hasn't assumed a responsibility at all, it just has the statutory duty. Paragraph 14, the effect of Hayden as adopted in goods is that the section 41 duty is no wider than that which rested on the inhabitants of the parish. Paragraphs 15, 16 and 17 deal with signage. No obligation under section 41 to erect signs, and in 17 no obligation in common law.
Well, that's because it's got nothing to do with repairing the surface of the highway.
That's in relation to section 41, my lady, but in common law it's because it confers a benefit. So on the facts of Gorringe, you had slow painted on the road, there was no need to repaint it. That was an omission rather than a positive act, and so there wasn't any duty to confer a benefit. So he deals first of all with section 41 and then the common law. And he makes the point importantly, paragraph 17F to G, that foreseeability is not enough. So if we are in a situation of conferring benefit, the fact that there is foreseeability that there may be an injury doesn't impose a duty of care. And so coming back to my Lord's question about the verge, it may be foreseeable that people will step off the highway onto the verge, but that's not sufficient for there to be a duty under section 41, and there is no common law duty to confer the benefit. And then in part, in answer to my lady's questions about the verge, if we look at 35.
Sorry.
Yes, my lord.
I'm sure this is important, but I haven't got it. On section 41, is referred to at paragraph 11.
So where are you, my lord?
I've gone back to Lord Hoffman, paragraph 12, now contained in section 41, duty to maintain the highway. First created 1961, statutory duty. And then paragraph 14 applies to goods in East Sussex.
Limiting to that duty to what it had been historically.
Well, requiring the highway authority to remove ice or snow is not repair.
No. But it's the first part of that paragraph, my lord. The duty is limited to that which was previously owed by the inhabitants of the parish. It isn't extended by section 41.
Goodness me, so you're saying that in every highway case, it's necessary to go back to the old authorities on liability of a parish?
No, my lord. I'm not saying that, and I apologise if I've conveyed that impression. What I'm saying is that the content of section 41 is to repair the highway itself insofar as that is necessary to allow the passage of ordinary traffic.
Yes.
Which is the same as the duty which was on the parish inhabitants. It is not to ensure that there is no danger. And an obvious example is that which my lady identified. Until the statutory amendment, there was no need to keep it clear of ice or snow, albeit that created a danger. Similarly, we say, well, it's foreseeable that if you step off that part of the highway which is used for ordinary traffic onto the verge, there is risk. That does not engage the content of the duty, because it is not that part of the highway which is used for ordinary traffic. And my lord, sorry. My lord, if I'm right about that, if we look at paragraph 17, just below F, it's not sufficient that it might reasonably have foreseen that in the absence of such warnings, some road users might injure themselves or others. Reasonable foreseeability of physical injury is the standard criteria of determining the duty of care owed by people who undertake an activity which causes a risk of injury to others. Insufficient to justify the imposition of liability on someone who simply does nothing. He neither creates the risk nor undertakes to do anything to avert it. And if section 41, as we submit, does not cover the verge because it's not used by ordinary traffic, then the fact that it is foreseeable, as the court has explored yesterday and today, that someone may step off the footway, and the fact that the verge has not been made safe for them to do so, despite it being foreseeable that that may cause an injury, does not give rise to a duty of care because there is no obligation to confer a benefit.
So, if that's right, then if there is a hole in a verge, however massive, there is simply no duty on the highway authority to do anything about it at all, either the statutory duty or the Commonwealth duty.
Yes. And one can imagine if there was land adjacent to a highway, quite a wide verge, and you got a hole at some point in it, and people aren't expected to walk from the highway onto that verge, because ordinary traffic just goes straight along the highway, then it's not within the content of section 41. And you can see a situation otherwise, because...
But it's not, if you're right, it's not within section 41, it's not within common law duty at all.
Yes.
Local authorities hard pressed financially, can say nothing to do with us, nor with anybody else. You'll just have to walk round it,
If you can.
if you can.
Well, you must be able to walk round it, because otherwise it would interfere with the passage of all
Yeah.
traffic.
Well, clearly.
So what you can't do is wander off, fall into a very large hole and say, you should have repaired that because it was adjacent to the highway, even though it was in a verge.
Yes.
So take a country lane with a number of rabbit holes in the verges. If I'm walking along with my dog and I walk up onto the verge to allow a car to pass, and I fall in a rabbit hole, is the highway authority then responsible for failing to fill the rabbit hole, subject to the statutory, or does that breach section 41, I should say? They may have a statutory defence under section 58. Does that breach section 51? Is the highway then in disrepair?
Well, we don't know. Has there ever been a case?
Well, I'll take you to two cases where it was considered, albeit not on those precise facts that I posited.
Because we have to remember that the issue in Orange, as Lord Hoffman made very clear at paragraph 38, was whether a common law duty could be created, if you like, out of the statutory duty. So they weren't really looking at the ambit of the statutory duty at all. What they were looking at, what the House of Lords were looking at, was whether or not there was a common law duty, which was, if you like, piggybacking off the back of the statutory duty.
Well, my lady, they absolutely were looking at that, but they started out by defining what the statutory duty was to exclude it from this case and to explain the interaction between the statutory duty and the common law duty, which is what this case does.
And the statutory duty that they considered briefly there was whether a slow sign was repairing the highway.
Yeah.
Yes.
And the Court of Appeal were unanimously agreed that it wasn't. And Lord Hoffman says he agrees with that and doesn't really have anything much to say about it.
Well, he says that in relation to signage.
Yes, which was
That's
what
what
that
the
case was about.
That case was all about the slow signing.
So then he moves on to common law to see if there was a way round that, for my part, relatively obvious proposition. And that's why most of it is about the common law duty.
Yes, but it's...
So I understand how and why you rely on that for the defeat of the second round of appeal in relation to the common law duty. But the first point, a verge effectively is not within section 41 because it's not part of the highway. That obviously didn't arise.
Of course not.
No.
But this sets out the principle.
I understand.
And then you have to apply it. I'm not suggesting he's dealing with this.
So on this, is there anything else in Gorringe on the statutory duty? Because I'm about to say when I read it, I had thought that this was principally concerned with the common law duty.
In relation on the statutory duty, there is some repetition of what Lord Hoffman said is by the other law lords. I just ask you to look at paragraph 68.
Can I also just say that this is the first appeal that I personally have done for about a year where there have been marked up passages down the side which have been the marked up passages to which we've been taken in submissions. It may sound an obvious point, but
Well
I,
done,
for my part,
everybody.
are very
Yes.
grateful.
Yes.
I know we're all very grateful for that indication.
So 68,
Yeah. That's the point about dangerousness.
Looks at the facts.
Well, you're encouraging me to take you to a similar case, so let me do that.
Yes.
now.
All right.
So there are two cases, and these are the only two reported cases we can find, and as I say, they're first influence. The first is Kine versus Newcastle, which is behind Divider 9. This is Mr. Justice Scott Baker sitting in the Administrative Court. And 3 and 4 describe the highway.
Is the case stated?
And then, if I can take the court, please, to paragraph 17, when my lords and my lady are ready. Mr. Kyde's complaint is as to the Crown Court's treatment of the verges.
Would you better tell us what happened first?
My apologies, that's why I asked you to look at 3 and 4. So, basically, you have a unclassified road in a rural area, primary single track used for farm access. Traffic generated by the local community also includes some heavy goods vehicles and taxis, which go to and from Newcastle Airport. It's not a busy road, both cyclists and walkers use it. Mr. Kind says it's being used as a rat run, and there's not sufficient width for the traffic. He wants it widened and reinstated pursuant to the duty under section 41. If I can then take my lord to paragraph 17, please. Mr. Kind's complaint is as to the Crown Court's treatment of the verges. Having found that the highway comprised the whole area between the enclosures, i.e. including the verges, it's noted that while the metal part of the highway was suitable for all traffic to pass along, the other parts were not. The finding that the verges are not suitable for all traffic does not amount to a finding that Prestwick car is out of repair. As Mr. pointed out, the critical finding is at 4am in the case. Prestwick's car is in a reasonable state of repair to serve the ordinary traffic using it. This is the application of Lord Justice Diplock's test in Burnside. Mr. Kind wants the road repaired, including the verges. He complains that the margins are not suitable for pedestrians, cyclists and horse riders. In my judgment, and Mr. Kind accepts this, he is seeking to put a gloss on the words of Lord Justice Diplock, so that they would read, put the road in such good repair as renders it reasonable passable across the length and breadth, and that is what is added, across the length and breadth of the highway. Length and breadth of the highway is added, for the ordinary traffic of the neighbourhood at all seasons of the year without danger caused by its physical condition. The Crown Court had to look at the whole highway. This it did. It correctly found that the highway included the whole of the width between the enclosures. But that does not mean that the council had an obligation to level everything and make all parts of it like a motorway, flattening banks so that vehicles could pass over them. The question was whether the highway as a whole was reasonably passable for ordinary traffic. In this regard, the character of Prestwick Park was of critical importance, and the Crown Court clearly had this well in mind, primarily a single track road used for farm access. In truth, what Mr. Kind is interested in is only the verges. I cannot accept his submission that the facts of Burnside are so different from the present case, but it's dangerous and erroneous to take the simple principle of Burnside and apply it to this case. And then at 19, there is, in my judgment, no inconsistency between the finding that Prestwick Car is in a reasonable state of repair to serve the ordinary traffic using it, and the finding that the verges are not suitable for traffic to pass along. The mere presence of verges, because they form part of the highway, does not require the highway authority, as part of its maintenance obligations, to extend the metal carriageway over them. While it may be desirable for the metal part of the road to be wider, that's irrelevant in assessing the road's state of repair. And in effect, what is being suggested by the judge through his argument about foreseeability, that this verge should have been improved to a state where people could come off the footpath and use it as a passageway.
Yeah, well, it wasn't being suggested that it was dangerous, it was just being suggested that it should have been repaired.
I mean, my lady, if you'd had someone cycling along the length of this verge, would the highway authority then have had an obligation to keep the verge in repair so that could be done? It is foreseeable that someone might choose to do so, but by so doing, you are changing the nature of the duty to that which the gloss identified there by Mr. Justice Scott Baker. You are in effect saying, put the road in such good breadth as possible across the length and breadth of the highway.
So this establishes that verges are part of the highway.
Absolutely, they are part of the highway.
So it's this point therefore turns on the traffic point. Effectively, that whether whether it can be said you have to repair it so as to have traffic in their neighbourhood on the verges as opposed to the metal part of the road.
Yes.
Well, yes, the question is identified in paragraph 18. The question was whether the highway as a whole was reasonably passable for ordinary traffic. And in that case it was, without having to do anything to the verges.
My lady, it was found that that part of the highway that was designated for passage, i.e. a single track road, was in good repair.
Yeah.
And if you came off that, if you went onto the verges, that did not engage the content of the duty. And that is made plain by what Mr Justice Scott Baker identifies as the gloss, which was sought to be put on the statement by Lord Justice Diplock in Burnside. Paragraph 70. Put the roads in such good repair as renders it reasonably passable. These are the words added, across the length and breadth of the highway for the ordinary traffic of the neighbourhood. And that is the gloss that the appellant resubmit seeks here. Because it is foreseeable that people may come off the footpath onto the verge, and we accept it is foreseeable. But that does not give rise to a duty, because as we've identified from Gorringe, foreseeability is not the test. It's not the content of this very particular statutory duty. My lords and my lady, the next case is Kennedy at 17. Divider 17, please. No, my apologies, not Kennedy. 18, King. We have looked for other authorities, but we have not been able to find them. Paragraph 2, at page 317, just briefly sets out the facts. So there's a mobile crane owned by the claimant being driven along Wood Eaton Road by Mr Lee Lawrence, came off the carriageway and toppled into a brook known as Bayswater Brook, which ran alongside the roads. The place where the accident occurs was at the end of the section of the road on which the southbound carriageway had been closed to allow for some proposed roadworks. And the issue was, in effect, if we turn to page 318 and look at paragraphs 4 and 5, whether if the claimant's primary case that the carriageway given way under, which the judge rejected, whether their secondary case was whether the crane had been driven on the verge and the verge was too soft for the crane, allowing it to topple over.
Well, you wouldn't expect somebody to be driving a crane along a verge, and so that we're not dealing with a parallel case at all here.
Well, my lady, with the greatest respect, I beg to differ. You can equally imagine a car coming off the side of the road onto a verge, and the verge being soft and the car's tyres going into it and that causing an accident. So again, the question is, does the highway authority then have a duty in relation to that verge to make it safe? Because it's foreseeable that that may happen. Foreseeable that this crane may go onto the verge. It's all about traffic along the normal route. And both of these cases identify that as a matter of law, there isn't a duty owed under section 41.
And therefore there's no duty under section 40, in common law either, and therefore there is
I'm so sorry, my lord, I missed
Sorry, there is no duty under section 41, and therefore you say, looking at Gorringe, there is no common law duty either, and therefore there is no duty at all.
I do, yes. But the common law duty is a slightly different one, because I do accept that by creating a cycle path, which ended with the footpath, I accept that that was a positive act. So the question is, was the failure to erect a sign an omission, or was it an unreasonable failure which created a danger because the path narrowed?
Yeah.
And we say it's not an unreasonable danger, and in any event, if the danger is that he was on a narrower path, there's no causation, it's not within the scope of duty, because what happened was you decided to overtake the jogger by riding up onto the verge. Can I take you please to page 334 in this judgment? And at paragraph 60, His Honour Judge Reddyhoff cites from Thompson versus Hampshire County Council, which is the Court of Appeal case dealing with the undulations in the verge, if I can put it in that way.
So sorry, which paragraph?
60, please, my lord, at page 334. I accept that. I apologise, my learned friend points out it's not sideline.
Even Homer not.
We'll do it now. Okay.
One can see that in one sense this case concerns the structural surface of the highway. From the relevant area of the path, the surface of the verges fell away into a ditch. However, the ditch was part of the contour of the land, even if the highway did extend over the verge up to the fence. To say that a ditch needs to be filled in or covered over so an even out surface of the verge could be tantamount to saying that all verge ditches would have to be similarly addressed as a matter of statutory duty to maintain the surface of the highway. However, that would be going hugely beyond authorities' previously understood duty.
This is rather interesting. If you look at paragraph 58,
I apologise, yes.
There's a reference to a Court of Appeal case called Russell and West Sussex Council, where it was held that the difference in height of 6 inches between the road surface and a grass verge was a potential hazard to users of the road and presented a danger such that the defendant was in breach of its duty under section 41.
Yes, my lady, but that's to do with the height of the carriageway. So what happened in that case is a car came off the carriageway and ran along the side of it. So it was disrepair in the carriageway. That was similarly the facts in T versus AR, which is the Lord Hughes judgment.
And the judge goes on at paragraph 59, says a different standard will normally apply to verges as opposed to the carriageway. There's a reference to kind.
And then he comes to his conclusions, my lady. Paragraph 67, page 336, please. He says, the question then arises, I'm reading 4 lines down, as to whether or not the state of the verge was such that it would give rise to a breach of section 41. As I've already indicated, it's clear that very different standards apply to a verge which is part of the highway, as opposed to the carriageway itself. The function of the verge is to support the carriageway, not to provide a safety buffer for overrunning vehicles or to support the weight of heavy vehicles. Many roads have adjoining grass verges, and it cannot possibly be the case that highway authorities are required to have verges of such firmness that they can support any vehicle which drives onto them. Mr. Mottram and Mr. Hill agreed that if any lorry or heavy drove onto the verge, the accident location would collapse. Now, and then he goes on to find no breach of section 41. Now, obviously, the facts are different. These are the cases that are available. But if someone stepping onto the verge, leaving a pavement, is owed a duty to ensure it's in the same condition as the pavement, in my submission that equates to the situation of assuming that the verge should be in the same condition as the metalled carriageway.
Of course not.
No.
A different substance.
Well, my lord, if you look at a pavement and a highway duties obligation, there mustn't be tripping hazards of, say, more than 20 millimetres. You can't be applying those standards to the verges.
Nobody's suggesting that you are.
Well,
I mean, here we've got a massive hole.
I accept that, my lady, but then you're into a sliding scale, aren't you? You're saying that you do have a duty to repair the verge, but only to a different level to the footpath, and then you're going to have to decide what that level is, and then you're...
So that it is in a fit state for people to use it in the way in which it would ordinarily be expected to be used, for passing and repassing. That's the point.
Well, but if you're passing and repassing, my lady, so if you're walking along the footpath, and you move across it onto the verge, then precisely the same defect as a tripping hazard exists.
Well, it's worse.
So you do have to then repair the verge to the same standard as the footway. Because if someone steps off the footway onto the verge, they're just as likely to trip on the verge as they are on the footway. I mean, why should a 10mm drop in the footway be any more dangerous than a 10mm drop on the verge? And if someone comes off the footway onto the verge and you have a duty to protect them against foreseeable injury, you need to make sure that the same defects aren't present. That is the problem. In effect, you are extending the duty to make the verge in the same condition as a footpath because it is foreseeable that if someone goes on the verge, they'll suffer injury.
I noticed that the case of Thompson, which is referred to in paragraph 60, which does seem to have some bearing on this, is not in the bundle of authorities.
No, my lady, it was because it was an undulation, and it seemed to me that that was a different proposition to a hole. We're not saying that this hole was a natural feature of this verge.
Yes, but actually looking at what's said about Thompson, the highway did extend over the verge.
I accept
But
that the
it
highway
fell away
says-
into a ditch.
Yeah, I accept. There's no dispute that the highway will include the verge, as it was in the case of Kind, which we looked at earlier, and my Lord Justice Coulson pointed out to me. The question is whether the Section 41 duty extends to the verge as well.
Well, just looking at what Lord Justice Ricks says, seems to me on the face of it to assume that it does, but it doesn't go so far as to extend to filling in a ditch.
My experience is reported cases are always easier than the one you're trying. I mean, of course, there's no liability on highway authorities to fill in every ditch at the side of a verge.
Well, that's why I didn't rely on Thompson, because it seemed to me
Yeah.
it would be a false point.
But as presumably, if either of you thought that we needed to look at Thompson beyond this paragraph, you would have asked us to do so. But what's said in this paragraph seems obvious common sense.
You don't have to fill a ditch, I agree entirely.
Yes. Doesn't help us much.
No, well,
doesn't
that's
help
why I
you
didn't
much.
put it in.
Yes.
But I will reread it, obviously, when I leave to see if there's anything there which assists. And
Well,
if there is-
all I was thinking was that if there had been a simple point, which is that you don't have to repair the verge at all, you might have expected that to have been flushed out in Thompson, without arguing about what the degree of undulation was.
well,
It's a little surprising that this point is sort of raised for the first time in this case.
it is, my lady, I accept that it's the first time it seems to be argued out in relation to a pedestrian. Maybe that's because claims aren't brought when people have accidents on the verges for precisely the reason I've outlined. Can we just look at, as we're dealing with highways and duties, Mills versus Barnsley, please? 4 in the bundle. And there are 2 marked up passages at P293 and P295.
Sorry, give me the tab again.
4, my lord, my apologies.
Mills,
Yes.
thank you.
This was a tripping claim in Liverpool with a small indentation in some paving. And if you go to 55, the paragraph which starts at the bottom of the page with the judge also, And the point on which we rely is the fact that a highway authority seeks to repair or inspect does not mean that the defect is dangerous. And I accept that the facts are dissimilar, but it's a clear principle. And then going across to page 57, this was a small defect which foreseeably could cause an injury, but when considering whether it was dangerous or not, Lord Justice Steyn says, halfway down the paragraph with the marking, it's important that our tort laws should not impose unreasonably high standards, otherwise scarce resources would be diverted from situations where maintenance and repair of the highways is more urgently needed. This branch of law of tort ought to represent a sensible balance or compromise between private law and public interest. The judge's ruling in this case, if allowed to stand, would tilt the balance too far in favour of the woman who has unfortunately injured in this case. The risk of a low order and the cost of remedying such minor defects all over the country would be enormous. In my judgment, the claim fails at this first point. Now, obviously, I accept entirely that that's a very different situation because the defect is much smaller, but the resources that would have to be deployed to make verges safe in the same way as footpaths are or pavements are for those stepping off them would be very considerable.
Well, that's the floodgates argument. The on the question of dangerousness, Lord Justice Dillon says the question is whether a reasonable person would regard it as presenting a real source of danger. Would you disagree with that?
Not at all. He's talking about somewhere where it is a passage for ordinary people. He's not talking about the verge there.
It depends on the defect, but
if,
that's what this case is about. It's about the extent of the danger, and all that the court has decided is that in that particular case the hazard was not such as to engage the liability.
My lady, that was a case involving the highway, and you're quite right. The court decided it did engage the liability, but we say there's two important points of principle there. One is resources, and it is relevant, as Lord Justice Steyn identifies. And secondly, the fact that you repair is not relevant to determining whether something's dangerous or not. And
yes, the resources argument put by Lord Justice Steyn and Lord Justice Dillon's reference to the bowling green and so on are quite well known in the trade.
Yes. Nonetheless, it's my obligation to at least raise
yes,
it.
indeed.
So you have it. So, my lord, that deals with section 41. I've addressed a number of questions. I'm happy to address any further questions, but I don't want to labour a point having made it.
Right.
Can I turn then to the common law duty of care? Because that
Yes.
slots nicely into this. And so we see from Gorringe that we are not liable for an omission. And that an erection of a sign, or failure to erect a sign, I should say, is an omission because it fails to confer a benefit. So the alternative then is, does the fact that we make a cycle path which leads into a narrow footpath which isn't signed create a danger? And it's worth looking at Yetkin at 13. And can I describe the facts of the case to the court? This was a road in Newham. The council had constructed a split crossing, so you entered it on one side of the carriageway, there were railings around it, you crossed the second point of the carriageway. And they had also planted plants around that area of crossing, which grew very high, so they obscured the view of oncoming trafficked pedestrians using that crossing. And a lady crossed against the lights and was hit by a car, and she had not been able to see the oncoming car because the bushes obscured her view. And Lady Justice Smith said that this did create a danger because the council, by planting the plants and then failing to trim them to ensure that there was a good view, had committed a positive act which resulted in the danger. And we see at page 218, paragraph 17, the separation between the private and the common law duties again. And then at the bottom, just below B, common law recognised the duty on any person not to create a hazard on the highway would affect the safety of road users. The extent of the duty would be a matter of fact and degree. The common law has only ever imposed the duty to do what was reasonable, open brackets, or avoid doing that which was unreasonable in all the circumstances. And then at paragraph 32, and I don't need to go through it, she explains that what Lord Brown was saying in Gorringe, there aren't two questions. Is it a positive act or a trap? It's a positive act which creates a danger which is unreasonable. You don't need to show trap.
Sorry, but which paragraph?
My apologies, my lord. Paragraph 32. And then at paragraph 33, she sets out the nature of the danger created by the positive trap, which I have tried to summarise to the court. If I can go back to Gorringe, please, deal with this point in relation to Lord Brown. Page 200 of the Court's bundle. Paragraph 102, he provides two examples of a positive act which creates an unreasonable danger. The first is a one-way street where you fail to put no entry signs, so someone drives the wrong way up it. The second is overtaking lines, which leads someone to overtake when there's a clear hazard. So, for example, coming to a blind bend. And then dealing with the slow sign, in this case, he at the bottom of the page refers, third line from the bottom, to warning overlay. However, is all too easily imaginable.
Sorry, which paragraph?
103, mate.
Yeah.
Last 3 lines. My lords, can I take you now to bundle A, please? To divider 1. This is local government guidance for signs for cycle infrastructure. And if I could take you to page A7, please. The end marking and the end of route sign. .4.1, the end marking refers to diagram, end of route refers to diagram, can be used where a cycle lane, track or route terminates. However, in practice they're often provided unnecessarily, possibly because of an assumption that their use is mandatory. It is not. 3.4.2, in most cases cycle lanes can simply stop. The sort breaks, such as where cycle lane is interrupted by a controlled crossing or a bus stop, indicating that the lane has ended, is never appropriate. Indeed, it's likely that for the termination of cycle lanes in general, diagrams are rarely required. 3.4.3, when deciding whether to provide them, consideration should be given to the purpose they're meant to serve. They might be useful where a route terminates at a hazardous location, but if the end of the lane track route is obvious, these diagrams would be redundant. If the cycle lane route has to concede priority on ending, give way signs is used instead. 3.6, cyclist dismount signs. Cyclist dismount sign to diagram 996 is another overused sign. On well-used cycle facilities, it's very rarely appropriate. And then at 3.6.2 over the page, in general, the sign should only be used in relatively rare situations where it would be unsafe or impractical for a cyclist to continue on.
E.g. at the foot of a set of steps going over a carriageway.
Well, that's how it was used.
Exactly.
Yes, my lady.
So entirely apposite to put a cyclist dismount sign where it was.
Yes, but that's not the complaint against us.
No.
Failed to put a cycling sign where the road, where the cycle lane ended and the footpath narrowed.
The complaint is not about a cyclist dismount sign, it's about a lack of an end of route sign, isn't it?
Yes, well, I actually think it may be in the judgment it's referred to dismount. It's clear that there wasn't a sign.
Yes.
The question is, does that create an unreasonable situation, a danger of the kind considered by Lord Brown in the two examples in Gorwich, or by Lady Justice Smith in Yetkin? And it's our submission that it did not. The learned judge, in his judgment, and we'll go to it in a moment, relied on the guidance. He relied on the expert evidence from the Claimant cycling expert that you could have signed it, but it wasn't obligatory. And he relied on Rule 13 of the Highway Code, which was wrong because it was the wrong version of the Highway Code. The last paragraph that you were shown was missing from the earlier version. My recollection is that that document was in the bundle put in front of the judge by the parties. I don't think he went off and did any research. So if there's any mistake in relation to Rule 13, I believe it's ours rather than the judge's. Or mine, certainly, because I relied on it. So it's certainly not the case in my view that he went off and did any research on his own. If we look at bundle A again, please. we go to divider 12. Page A98. You can see the footpath in the top photograph, and then you can see the view taken north along this stretch of the A10 from under the Portcully Bridge, which shows the cycle track, which then widens to become the which narrows to become the footpath. Apologies. So, and there's a more immediate photograph of that, which I think you've already seen, A99.
Yes.
And it narrows because the verge widens.
Yes.
And that appears to be, because the road alignment doesn't change, but you get to that sign that we can see the back of, and then it fairly obviously narrows because there's now bush and greenery where there was previously a concrete
I don't think,
track.
with the greatest respect, my lord, I think it's the other way round. So I think they got rid of some of the verge when they widened it. So what happened was the footpath had been there for some time,
Oh, I see.
and then they created this cycle track up to the bridge.
Okay,
So
but,
they're cut
okay, so
into
that's
the
the
verge.
sequence. But so the sequence may be that way around, but it doesn't detract from the point that it's not a change due to anything else except that the verge is either narrowed to make the footpath wider, the cycleway wider, or narrowed to make it narrow.
You have a wider cycleway,
Yeah.
a narrower footpath with a verge on both sides of it.
Yeah.
And as we can see, for example, if we go back to A98, the verge is really a barrier between the A10 and the cycle path or footpath.
Yeah.
Yes,
And there's a hedge on either side, so it's not a verge that one would expect anyone to be crossing. And the simple point we make about A99 is that it is self-evident to anyone cycling north, as the appellant did, and then who cycled back south, that the footway is of a different width.
yes, but does that necessarily show that it's suddenly become a footpath and not a cycleway?
My lady, it may not do. But in my submission, that's not the issue.
And cycles aren't allowed to cycle on footways, are they?
No.
So why is that not a parallel with going up a one-way street when there isn't a sign to show that you should be not going up a one-way street?
Because the danger, insofar as it exists at all, is of an entirely different character.
It's a danger to other users of the footpath.
If you, my lady, well, to take my lady's point, if you had someone cycling on a pavement and they banged into a lamppost, the highway authority wouldn't be liable for saying you shouldn't have cycled on the pavement. The reality in Lord Brown's examples is that the motorist in both cases is being exposed to a danger that he can't see. He's not aware
It's a
of.
danger to him as opposed to a danger, or it's a danger that is to him as well as to others, you say, as opposed to this situation where it's just a danger to others?
I don't say it's necessarily a danger at all. The evidence was, led by the claimant Mr Crooks, that people had been using this footpath before the cycle path to cycle on for many years. And the survey was, which was done in November, I think, 2020 or that there were 18 cyclists and 18 pedestrians in a day. 21, apologies.
Well, it was at the beginning of COVID.
And the Strava shows that people were regularly using this to cycle. So it's very distinct, entirely distinct in our submission, from someone driving the wrong way up a one-way street towards oncoming traffic, or someone being forced to cross at the sheep pen, which was the description given in Yetkin, when they cannot see oncoming traffic. What you had here was a cyclist who was cycling on a narrower path than he had been previously. That does not create the unreasonable danger identified by Lady Justice Smith in Yetkin or by Lord Brown in Gorringe. The only danger that is said to arise is it's not narrow enough for him to pass.
Not wide enough. Not wide
Wide
enough.
enough.
You're quite right, my lord, I do apologise. Not wide enough for him to pass. That is not of a similar character. It is not an unreasonable danger, and in fact the evidence was that most likely you could pass, and cyclists and pedestrians did pass. It was 1 metre to 1 metre too wide. And so it's our submission that as a simple matter of fact, this is not at all the kind of positive act which creates the unreasonable danger which is identified in those authorities. It's entirely distinct. But secondly, we say, if there is a danger, it hasn't caused this accident, because it wasn't a danger arising from the width of the footpath. He didn't collide with someone coming in the opposite direction. This appellant chose to ride up onto the verge. Now, he may have done it to pass someone, but it wasn't a required or necessary act. So it's completely dissimilar from the motorist who is trapped into driving the wrong way along a road, or the pedestrian who has to cross when her view of traffic is blinded to her.
Why does she have to?
Because that's where the local authority...
I appreciate that you retained your finding of 75% contributory negligence, but why was it necessary for the claimant in Yetkin to cross the road?
That was where the local authority had directed her to cross the road by creating...
Sorry, no, of course, she wanted to cross the road, but why was it necessary for her to cross without waiting for the green light?
That wasn't the point, my lord. And I say that because I was the advocate who took a bad point in that case, as Lady Justice Smith decided.
Yeah.
If she crossed when the lights had been in her favour and a car had been coming in the other direction, you're still expected to check. You still need to see what's going on. So it wasn't that she was in part at fault that gave rise to the danger. The danger was the crossing, and it obscured her view of oncoming traffic, whether the lights were against her or not. And we say that's very different, as is the situation where the highway authority channels the traffic in the wrong direction and gets you to overtake in the wrong position. We say that they are all different because in some sense they remove the choice, they expose the claimant to danger in a way that doesn't happen here.
Well, it was also found in that case that it was entirely foreseeable that people wouldn't wait for the lights to change if the road was clear.
It was entirely foreseeable that on occasions people will not follow the lights. Yes. But that was still the precise danger which they had created. That's not the case here. The fact that he rides up onto the verge is not a direct corollary of the narrowness of the width.
Well, if somebody was coming in the same... the alternative is to get off the bike and wait and I suppose wheel it round the person, or just stick behind the jogger.
Yes, and it was only 50 metres until you got to the wider point in the road, to the cycle path as he came back. But basically, he decided to overtake, and the path was narrow, so he went up onto the verge. And we say that factual situation is clearly distinct. I mean, it has a kind of simple chain causation, but if one's thinking about whether it's related to the danger or not, our submission is it's not the danger which they should be protecting, which they created on the claimant's case. We say there isn't that danger, but if there is, we say it's not caused. Right, I've now, as it were, gone back to front, unless there's anything else I can assist on in relation to common law section 41.
No, right.
So now I need to deal with Mr. Cook and tracking devices, etc. So I think I explained that our case was not in the alternative. I think I dealt with category 1 and 2. Can I then deal in a little detail with
except for this, I know it's a simple question. The judge doesn't seem to have actually decided whether it was category 1 or category 2.
No,
We're having to do our best to translate it. The closest we get, is this right, is that he found that it was dangerous but that repair wasn't urgent.
Yes.
Which appeared to, on its face, to potentially be contradictory. But he never actually says, therefore it's 1 or therefore it's 2.
I was quite wrong, and I shouldn't have interjected when I did yesterday and said he found it was category 2, so I apologise to my learned friend for that.
So we don't know, is that right, what the judge thought of this issue on which so much time seems to have been spent?
Yes, I suspect that. I mean, sorry, what I haven't done in relation to the points I've just made, and I'm very grateful to my Lord for reminding me, is just taking you to the judgment and dealing with those points. So if I may, if I take you, please, to, maybe I could just deal with the structure of the judgment, because my lady has made comment on it, so I should try and defend it if I may, please. So what he does is he sets out the law initially, and then at the bottom of page 90 in the judgment, he cites AC versus TR, and it's a judgment by Lord Justice Hughes, as he then was. And he sets out the approach that one should take in a highways claim, section 41, causation, section 58. And then he recites the evidence. And then, if we go, please, to page 104, he makes findings about the size of the hole and whether it was present on the 13th of February. And then at page 107 he deals with section 41, 109 causation, and then and section 58. And really it was important to, as it were, illustrate that that's what he's doing because of Lord Justice Coulson's question yesterday about contamination between findings about whether the hole was present and whether the inspection was conducted. So he has to consider first, as a matter of fact, whether the hole was present, and he does that. Then he goes to section 41, and then he goes to section 58.
Where does the judge actually deal with the point that you've just been addressing us on, Mr. Weitzman?
Sorry,
as to whether or not there is ever a duty to repair a grass verge? Where does he actually deal with that?
Certainly. He starts by identifying the legal test at paragraph 116 on page 107. And we say he gets that right. Then if we turn the page, please, my lady,
Yeah.
he deals with 121. And we say that he has applied the wrong test because he's said it is foreseeable. And you've heard my submissions on that. And then he repeats that at 123. Particularly 1232, foreseeability. And then at 1233, he talks about a real risk that a pedestrian might step into the hole or a cyclist may cycle into it from the footway, notwithstanding its proximity to the road sign. And then at Roman 5, he says this is the kind of damage that members of the public would reasonably expect to be remedied. And we say that real risk is another way of saying foreseeability, and public expectation isn't here nor there. It's a matter of law. And addressing Lord Justice Coulson's question, 121 and 122, he deals with the DMA in category 2. And then he goes on to say, I find that the defect in this grass verge, I'm reading from 123, my lords.
Yeah.
Was dangerous.
And called for repair, albeit it was not urgent for the following reasons. And again, we say if it's not urgent, it doesn't fall into the definition of dangerous, because by definition, if it is dangerous, it does require urgent repair.
No.
So what he's really doing is applying a much more common law test, the kind of test you might apply to an occupier under the 1957 Act. He's saying people might step off, it's foreseeable that they might, that gives rise to a duty of care, but it's a graduated duty of care because there's less of a risk of them doing it than elsewhere, despite the size of the hole.
Yeah, but you say
I say that's the
there can't
way.
be any duty of care at all, so that's that.
But I say that reasoning is incorrect. If he was going to say there was a duty of care under, a statutory duty under section 41, he would need to say it is ordinary passage for people to be going up and down the verge. Does that answer your question, my lord?
Yes.
That's great.
Yes. Thank you.
So again, if I can go back and try and deal with Mr. Cook's evidence, the starting point is, I think we both agreed during the discussion with the judge that it was a curate's egg. And by that I mean part of it was good for one of us and part of it was bad for the same person and vice versa. So
Not unlike the judgment.
Hmm?
Not unlike the judgment.
When I was quite junior, I front of Lord Justice Sedley, he said to me, Mr. Weitzman, this judgment's a bit of a curate's egg, isn't it? And I didn't know what a curate's egg means. So I did the obvious thing, which was nod in agreement, but I then went and looked it up, and I'm very pleased that I've been able to address this court knowing the proper meaning of a curate's egg. Yes.
It was a punch cartoon, wasn't it? Or was it a cartoon?
I think it most likely was by then.
Anyway, we need not go into that.
So, he says he carried out a walked inspection. If a hole had been there, he wouldn't have missed it, which favours the respondent. He says if it would have been there, it would have been a category 1 defect. It's incorrect to say that there can have been confusion between a driven and a walked inspection. It was always going to have to be a walked inspection because you could not inspect this footway from the ATEC.
Exactly.
think we can work. I think we can work that out
Yes,
without.
But it was also
expert
specified as a walked inspection, so he couldn't have done it as a driven inspection. It wouldn't have been valid. And he says, you know, this is a regular walked inspection. This is how it's done. His statement was taken in telephone calls between the 22nd of October and the 10th of June 2022. It was said, why wasn't the tracking data dealt with in the second phone call after it had been sent to the defendant? I've taken instructions, it was simply overlooked. It had been sent to Mr. Cook, but it wasn't dealt with in the statement. Can I deal with the tracking data? Because, my lady, you wanted to address this. It was in the trial bundle. It was part of the documents before the court with the caveat that you've seen in the
We
defendant's
don't
email.
accept that it's necessarily accurate, whatever that means.
I'll address you on that when we get there. But, in fact, it was only relied upon and only came to light in my learned friend's written closing submissions. And that's important for two reasons. Firstly, yesterday it was said that the proper authorities weren't before the judge, but we only knew that they were using it to impugn Mr. Cook's evidence when we got the written submissions, and it was raised for the first time. And to be frank, I had failed to spot the importance of the document until it was referred to by my learned friend, as had he, and I will take you to it after lunch, but there's a point in his closing submissions when the judge says, you cross-examined, you would have had a great cross-examination of Mr. Cook on the document. He said, I can't take any of the credit, it was my instructing solicitors who identified it. It wasn't...
Yes. Sorry, I wasn't by that suggesting that we were unaware of the point, simply that my instructing solicitors identified it.
Yes, that's what I'm saying. It wasn't put to Mr. Vine, who was a contracts manager at Ringway. So if there was clarification needed of that document, which had come from Ringway, not the defendant, it could have been sought in cross-examination with Mr. Vine.
Well, what could he have said about it?
Well, he could have explained what it meant, or he could have said, I don't know. But there was no attempt to clarify what this document is and what it shows.
Well,
Now, I'm not critical of my learned friend because obviously he wanted to
I
deploy
would have
it.
thought it was fairly self-evident what the document is and what it shows, Mr. Waxman.
Well,
What it shows is that Mr. Cook didn't get out of the car.
well, my lady, if that's right, it's wrong to suggest that the allegation against, sorry, that the case against Mr. Cook wasn't that he was, it was that he was mistaken, not lying. Because if he didn't get out of the car, and that was clearly what was being said to the judge, one, he falsified the report.
Not necessarily, because if, as you are now telling us, your instructing solicitors omitted to put this GPS data to him, so he never saw it, he's trying to remember, over a course of 2 telephone conversations, a particular inspection that he thinks he did. And he could perfectly honestly think, oh, well, this is the way I always do my inspections, and I know I did an inspection on that date, and I've got the document which says I did an inspection, so this is what I must have done.
No, my lady, because he can only have created the document if he'd done the inspection. If he had done the inspection, how could he have created a document saying, this is my inspection?
Well, we're talking about the walked inspection.
Yes.
I think it's common ground that he was somewhere in the area on the day, and that he was driving his car or his employer's car, doesn't matter which,
It would have been his employer.
did that route. That, so far, so good. The question is whether he got out of the car and did a walked inspection of this specific area. And speaking for myself, his statement says a great deal, I would have done this, I would have done that, I would have done this, I would have done that. If he had come, it's not very difficult to see how the first 5 minutes of cross-examination
I agree, mate.
would have gone.
It would have been said that the tracking data showed he hadn't done the inspection and he was lying about it.
No, just you say you would have done this, you would have done this, but it's pretty clear from this that you didn't, isn't it?
Well, but my lord, remember he's filled out a document saying that he's been there and seen it.
Did the document remind me? Because
Yes, I'll take you to it,
the document that he filled out, does it actually talk about a walked inspection?
I don't think
because my recollection is that his witness statement did, but not the contemporaneous document. But I need to be corrected if I'm wrong about that.
it's appended to his witness statement, my lady.
Yes.
His witness statement is at A113, and the documents are at A121, which is the 1st and the 16th of August 2019. And the second one is A122 on the 13th of February 2020.
A121.
And the point made by my learned friend is the two are identical.
Yeah.
Yes.
The judge finds that it's perfectly acceptable to have a replication because if nothing's changed, you can make the same entries. But he cannot have sat in his car and not done it and honestly filled this document out.
Sorry.
He cannot have sat in his car and not walked the footway and filled in this document honestly, because this document is him saying, I have carried out an inspection of the footway, and we accept that he couldn't have done that from the car. So it was always going to be, you said you've done it, and you did not.
It's always going to be.
You said you've done it, and you did not do it.
Right. Well, now let's come to the point of law. The question is whether it was impossible for Mr. Porter to challenge Mr. Alan Smith on categorisation without putting in and adopting as his own witness statement
Yes,
the witness statement of Mr. Smith.
Can I deal with the chronology turning to that question?
Yes.
First, at the start of the trial, so in January, we put in the pre-trial form that he wasn't covered. Then you had the Civil Evidence Act notice in February. At the start of the trial, my learned friend objected to that statement going before the judge and that evidence being included. And that objection was never withdrawn. The claimant's witnesses gave evidence on the first day of trial. The defendant's lay witnesses gave evidence on the 15th. My learned friend cross-examined first Mr. Vine and then Mr. Alan Smith. At the end of Mr. Alan Smith's evidence, after I'd re-examined, I asked if he could stay because I wanted to take instructions on the Hertfordshire cycling map which my learned friend had produced to cross-examine him on, which I hadn't seen before, as my learned friend alluded to yesterday. In that shirt adjournment, I made it plain that we were not going to rely on Mr. Cook. In part because he was a curate's egg, but also, as Justice Bean has identified, very little weight could have been put on his statement at all, given the circumstances of his Civil Evidence Act hearsay notice.
Well, I'm right.
query whether
It would be inadmissible unless Mr Porter agreed, wouldn't it?
If we had fought the application and asked it to be admitted, I suspect I would have lost it.
Well, I don't know. It's
So
a long time since I looked at the Civil Evidence Act, but I thought unless
it
it's
is
one of
not
the...
one of the identified reasons.
No.
I absolutely accept. So either my learned friend would have had to agree it, or he would have had to, he'd have rejected, and the reality is it most likely wouldn't have gone in, and if it had gone in, the weight that could be attached to it would have been limited.
So the fact that Mr Cook's statement was not going, you were not going to have a fight with Mr Porter about whether it should go in or not, was not actually clarified until some way down the date of the trial.
At the end of our lay witness evidence. There
Right.
didn't.
So up till then, it was always possible that there was going to be a fight on it, which you thought perhaps you might lose.
But if I can take you to bundle B, please,
Yes.
and we deal with the opening. It's B32. And if one reads from line 18 on B32 to line 15 on B33, I'm conscious of the time.
Sorry, which line did you say?
My lady, line 18 on B32.
18.
Sorry, Mr. Weitzman, I distracted my lord and myself, so I didn't get that reference.
I was taking you to my learned friend's opening on the first day of trial, which is at B32, and the relevant entry starts at line 18 on B32 and continues over the page to line 15, where he makes it plain that because Mr Cook doesn't want to come and give evidence, that's not a good reason for attending court. And then my lordship may be invited. How would you like me to deal with, I'm reading from line 10 and 11 B33, by my learned friend to permit some evidence that we resist. I'll obviously leave him to make that application. As I've already outlined, it's in relation to Mr Cook. And so it got to the end of our lay witness evidence and I informed him that I was not going to make the application. And I don't know if that's a convenient moment or not.
Yes, now we're in trouble on time. How much longer do you think it'll be? I'm not asking that as a hostile question because you only started at 11:15.
Well, with the assistance of the bench, I think I've gone faster than I might otherwise.
Right.
So if I'm an hour to an hour and a half, depending on how much we're discussing Mr Cook's evidence, that will leave my learned friend between an hour and a half to respond.
Yes, because you spent a good deal of your time, understandably, on the respondent's notice issue, which Mr Porter hardly did more than allude to. So,
but my lord,
yes.
just dealing with the appeal, as I pointed out when I stood up, they took some 4 3/4.
Yes. I'm not apportioning blame.
Happy to, if you want to, yeah.
Shall we break off now? It's almost 1:05. Shall we say 1:45
Certainly,
to resume?